Hello, everybody, and welcome. As many of you know, my name is Parveen, and I'm with the John Humphrey Center for Peace and Human Rights. And thank you for joining us for this virtual information session on using Access to Information Act requests to advance accountability. Before we begin, I do want to acknowledge the land that we are on. I know that we are all coming from different parts of Turtle Island. JHC is located on Amiskwaci, or Treaty 6 territory, the homeland of the Cree, the Blackfoot, Métis, and other nations. I'm joining you from Takaranto, covered by Treaty 13 territory, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. And we pay our respects to the First Nations and Métis ancestors of this land that we are on and reaffirm our relationship with one another. And before we begin any kind of human rights work, we always have to go back to the land and to recognize that this land has a history that predates us. It is marked by forces such as colonialism, genocide, and erasure, and it continues to impact and shape the realities that we live in today. And doing human rights work means acknowledging this and committing to engage and unlearn and decolonize our mindsets in ways that are respectful and reciprocal. For those of you who may be new to our work, although I know everybody here is very familiar with the work that we do, JHC is dedicated to advancing human rights through research, dialogue, education, and advocacy. And our goal in hosting sessions like this is to provide practical knowledge and tools that community members and that people can use to engage with systems, to advocate for themselves, and to promote transparency and accountability. And so this specific session is part of our Breaking the Cycle, Legal Education and Reform for Criminalized Communities. And this project is funded by the Alberta Law Foundation. This project is a 1.5 year initiative that we are just kicking off now, and it is focused on research, engagement, and education and policy dialogues around fines, such as bylaw fines, that impact those who are living in chronic poverty and without stable housing, as well as looking at how it further puts them into debt and limits their access to justice. And so this session is intended to help provide those tools and strategies through Access to Information Act requests. So this is really intended for individuals and organizations to better understand decision-making, support systemic change, and advance accountability in public institutions. And so for this specific project, Breaking the Cycle, we are really keen to learn how we can use this tool to access information to better inform the levels of debt and fines that people may be carrying that are inhibiting their access to other basic human rights. So with that, it is my pleasure to introduce our speaker today, who will be leading us in this information session, Chris Wiebe, who is a lawyer at Engel Law and a volunteer with Justice and Equity Alberta. Chris practices civil litigation and administrative law and is a longtime collaborator and friend of JHC. He helps clients with lawsuits against police and prisons in the Court of King's Bench and administrative complaints against police and peace officers. He has also acted as co-counsel for the Coalition for Justice and Human Rights in its constitutional challenge of the City of Edmonton's encampment eviction policy. And so today, Chris is going to be walking us through how to access to Information Act requests, which you may know by its former name as FOIP requests. So how they work in practice, what types of records can be requested, and how individuals and organizations can use disclosed information to better understand decision-making. So if you do have any questions or comments, please drop them in the chat and we will get to them at the end of the session. So with that, I will turn it over to you, Chris.
Thanks, Parveen. And hey, everybody. Apologies in advance. I'm a bit sick today. My voice is pretty monotone under the best of circumstances, but when I'm like congested like this, it's going to be especially hard to hear. So if at any point anybody can't understand what I'm saying, just let me know. Don't feel bad. Happy to be here with you all. Thanks, Parveen and Renee, for having me. As Parveen said, my name is Chris Wiebe, pronouns he, him. I'm a lawyer at Engel Law, and I'm here as a volunteer from Justice and Equity Alberta, which is a new nonprofit of lawyers and non-lawyers looking to advance more public interest litigation and legal advocacy in Alberta. Um, so I have a little bit of experience with access to information requests going back to 2019. So I'm happy to share what I've learned in my time doing them. And no doubt there's some other people with a lot more experience than I have out there. So I'll have some resources at the end that you can check out to continue learning. I'm just going to share my screen here. Bear with me. Got some slides. Can everybody see my slideshow? Cool. So I wanted to just start out by stating that accessing government information isn't just uh, like something that we get to do, or it's not a privilege. It is part of our constitutional rights under Section 2B of the Charter, the freedom of expression. That being said, as you can read in this quote here I got from former Chief Justice McLaughlin and former Justice Abella of the Supreme Court of Canada, it's not an unlimited right. So we have a Section 2B right to access information in the hands of our government, but only as is necessary to permit meaningful discussion on matters of public importance, subject to privileges and functional constraints. So there's a constitutional right. It's not an unlimited right. Just wanted to start there as we talk about how to access government information. So today I'm going to be talking about requests for general information or non-personal information. This is the kind of information like data or government records not related to you personally. So this is this sort of work that's typically that I have more experience with in requesting data from governments in order to do um, actions to hold government accountable. Um, those are all requests for general information. Personal information uh, is different. If you want to request your personal information or the personal information of someone else in the hands of a government, you can do that yourself, or if you're doing it on some behalf of someone else, all you need is their written consent. It's a bit of a different process. There's no fees, generally speaking. So today I'm only talking about general information because this is the kind of request that is more relevant to our discussion here. Okay, so I'm going to talk about the relevant legislation and the changes from the FOIP Act to the Access to Information Act in Alberta that Parveen talked about. Um, I'm going to talk more about what you can't access than what you can, because what you can is pretty broad. It's more helpful to talk about the exceptions to what you can access. Some stu examples of what I've accessed in the past, how to request information, how much you should expect to pay, time estimates, and what to do if you get a decision you don't like or disagree with and you want to request a review. So there's two statutes or laws to keep in mind that govern access to information in Alberta. There's the Provincial Act, the Access to Information Act, formerly called the Freedom of Information Protection of Privacy Act, that governs public bodies that are part of or created by the government of Alberta. So this is what's going to apply if you're requesting data from police services or municipalities or Alberta Health Services or the government of Alberta, obviously. Um, they charge $25 per request for general information, and decisions get reviewed by the Information and Privacy Commissioner of Alberta. Then there's the federal, it's very similar, only that it applies to federal entities, and the filing fee is $5. So I guess federal information is cheaper than provincial information. Um, and Similarly, decisions get reviewed by the Information Commissioner. So, as Parveen mentioned, there's a change in the legislation in Alberta recently. We used to call it FOIP requests or FOIPA. Now it's called ATIA. Um, this change is effective December 11th. Um, I haven't noticed any major changes in my personal practice from this, but I note that there are some changes. There are more exceptions from disclosure, meaning like more records you can't access anymore, um, like such as court records or prosecution records, records that will be available publicly, like records that the government says they'll release soon without a request. And then like political communications between staffers are now exempt. Um, it defines electronic records, which is kind of nice. It does narrow the duty to assist. So um, basically what that means is like each public body has a FOIP department or an access to information department, and they have a duty to assist you in your request, like because they know what records exist, you don't. Generally, they're supposed to kind of help you work on a wording for your request that will actually turn up the results that you want and isn't too expensive. So now they've narrowed that a bit to be subject to like no, normal computer hardware and software and technical expertise. So slight narrowing there. I'm not exactly sure how that'll play out. Um, Also redefines day to business day, so it just means that the deadlines are a little bit longer now. Okay, so generally it's a pretty broad right to access information. So it's these are exceptions to the rule that you can access government information. So some things that you can access are disclosure that could harm a third party business or violate personal privacy of a third party, could pose a risk to public health or public safety, harm a law enforcement or other investigation, investigative technique or confidential informant, national security, intergovernmental relations, economic interests of a public body. Um, and then this one's new in Alberta. There's exception to disclosure of uh, information subject to cabinet confidence and advice from officials. I don't have as much experience with this one, so I'm just going to say it's there. I don't exactly know how it would apply. And then also there's privileged information, which is usually like solicitor-client privileged advice from government lawyers to government officials. That's exempt from disclosure. So just to give you an example of stuff that I've been able to access in the past, I know we all have very different areas of advocacy that we're working on. So I just thought I would just give you some examples of what I've done. Not sure if that would apply to the projects that you all are working on, but so I've accessed numbers of tickets issued by city peace officers to people with no fixed address. I've done that like most years since 2019, where I get a breakdown of all the tickets they're issuing to people with no fixed address, who are mostly unhoused people, to under various bylaws or provincial laws in the city of Edmonton. It's helpful for discussion on the way that our local laws impact people who are unhoused and make it more difficult for them to leave poverty. Um, I've been able to access information on like racial breakdowns of ticket recipients. This one I don't think every public body is going to have, but the City of Edmonton Peace Officers or the City of Edmonton FOIP Department has been able to give me data, and not just me. Uh, Moira Whiten from the Edmonton Journal, formerly of the Edmonton Journal, got that data first, back in like 2018 or something. Um, and then there's yeah, policies are an easy get. I've gotten police operational plans and expenses, emails between police leadership. I've gotten health information about ambulance interactions and emergency room visits and diagnoses related to frostbite among people with no fixed address. I wasn't the first one to do that. Taylor Lambert from the CBC um, was the first one, and I got a little more information on that that he used in one of his more recent stories on it. And then I've gotten government media talking points before, like kind of memos that they circulate amongst the ministers to say what their talking points are going to be on an issue. Um, so anyways, there's a lot of different stuff that you could access. Those are just some examples of what I've gotten. So how to request records and information. So as far as the application form, each public body is different. So just go to the website and it'll tell you. As far as how to word the request, it's very, specific to the information you want. This is going to sound like nothing, but just carefully word your request to include everything you want and exclude everything you don't want. That is close to meaningless, but start there. I usually try to start big in scope, um, reasonably big in scope, and then I narrow it down if they end up charging me or quoting me a lot of fees for the request. Um, because when you submit the request, like say you're asking for all government data for like 5 years on a particular topic, they might come back at you and say, it would take us like so many hours to do this. Here's a quote for $500. Are you going to pay us $500 so we can do this? And obviously, most of us aren't going to have $500 for that. So what you do in that circumstance is usually you talk with them about how to narrow it down. Maybe you only do 3 years. Maybe you only are requesting some of the data you're wanting, or maybe you're just requesting the government records, and then you can just manually uh, derive the data you want from that. There's a few different ways that you can narrow it down later on, but start big and then let them tell you it's too much and narrow it from there. Um, One thing that the journalist Charles Resnell has advised publicly doing is to begin your requests for records with just this boilerplate language, which is I request all records within the meaning of Section 1U of the Access to Information Act, or all electronic records within the meaning of Section 1F. That way, you're you're not limiting your request beyond what the beyond what the statute sets out. It's you're requesting the full extent of the types of records that you have the right to access under the Act. Um, Sometimes it can be helpful to attach a document explaining more what you're talking about, what you're asking for. So sometimes, like a news report, like referencing this public uh, story, like asking a question about that, or asking for records about something that a government minister said in a news report. Or usually when I'm asking for like a lot of data, it ends up looking really confusing when I like type it out in a paragraph. So I just send them like a blank table and just ask them to fill in the blanks. That usually is a lot easier for them to understand than explaining with words what information you're after. Um, and one other thing that is helpful boilerplate language to use is, and this will be relevant later on, but if you're asking for information that you're planning to disclose publicly because you think it's of a matter of public interest, include at the end of your request a line that says the record relates to a matter of public interest within the meaning of Section 96 sub 5 sub B of the Access to Information Act. If you don't have the citation, it's not a big deal. If you want to just say this matter relates to a matter of public interest, then that's good enough. They should know what you mean. We lawyers like just to flex our lawyer muscles and include citations wherever we can. Um, okay, how much you need to pay? So yeah, every request there's a fee. In Alberta, for provincial records is $25 or municipal records. And then federal records are $5. Just that, then that's just to get you in the door. Like that's just to get them looking at your request. And then in Alberta, if they review your request and they decide that it's going to cost them like more than $150 or $150 or more, then they're going to send you a quote saying, pay us like 200, 500 or whatever, and we'll get you this information. So um, at that point, you have a couple options. You can narrow the wording of the request, as I talked about earlier, um, or you can ask for or reiterate your request for a fee waiver, a public interest fee waiver. Um, Section 96 sub 5 of the Access to Information Act allows partial or total fee waivers if you can't afford to pay the amount quoted or if the matter relates to an issue of public interest, such as the environment or public health or safety. So um, I usually try both, um, narrow the request um, and ask for the fee waiver. You're pretty much entirely in their hands at that point, so you want to be kind of nice to them. Um, because if they give you a decision that you don't like, as I'll get to, you'll have to request a review, which would take a couple years, unfortunately, in Alberta. Um, I don't know the timeline federally, but I've heard it's also quite bad. So, practically speaking, if you're trying to get the data or records relatively quickly, like within a few months, better to just work with them, and just to try to get the cost of the request under $150 so they don't charge you anything. Um, so how long does it take? Under the legislation, they have 30 days to respond, but they almost always ask for an extension, and they have the ability to ask for unlimited extensions. At any point, you can decide that your patience is up and you're requesting a review, but that's not likely to make things speed up any. Um, Normally, I've waited like 3 to 12 months for responses to access to information requests in Alberta. Um, Federally, it could be longer than that. And then if you request a review of any decisions, it'll take years. Um, so yeah, if they make any decision about your request, like withholding records or charging you a lot for the records, you have the ability to request a review of that decision, or including ask their request for extensions beyond the 30 days. You can request a review of that too. Um, so the Access to Information Act set up these commissioners for overseeing these complaints and requests for review. Um, Usually have to request that review within 60 days. Um, I would only resort to this if you're okay with waiting a long time, um, or um, or if you're okay with requesting the review of the decision, and then on top of that, at the same time, going back and rewording your request and resubmitting the request to try to get the same thing, um, just in a narrower wording. Um, Governments obviously are their self-interest is often uh, opposed to disclosure of government information. I don't think I need to explain that. And so the often the way that they sort of um, fight, not fight back, uh, well, they tend to like inadequately fund these commissions, like for reviewing uh, disclosure decisions. So these commissions, the offices of the commissioners are pretty overworked, and it leads to very long delays. Um, so that's why I say that not to resort to it if you're in a rush, or not to depend on it if you're in a rush. I'll give you one example. I did a request to the Ministry of Community Services in Alberta, like in summer of 2024. Um, and uh, they 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 gave me like a very unreasonable decision. Um, and I decided I wasn't in a rush for the information, so I just requested a review because I wanted the Information and Privacy Commissioner to set them straight on this one. Um, I think like 9 months later, the commissioner's office called me and said that that problem that I was having was like an epidemic, and I was like one of 70 or some requests for review on the same issue. And so then they launched an investigation. The investigation took like a year, and that came out like a few months ago. And now I'm waiting for them to respond to my individual request for review now. Um, so that was a request for review where the government is like obviously wrong on it, and has been set straight, but now I'm still waiting, over, yeah, it's been like, I guess a little over a year and a half now. But um, yeah, so anyways, the request for review process is not fast. So yeah, I'd recommend considering if the information might be available elsewhere, or try to reword the request to get around their blocking of disclosure, or exemptions to disclosure, I should say. Um, but if you get a bad decision um, that feels unjust, that is blocking information unreasonably on a matter of public interest, don't be afraid of doing the request for review. I do recommend it, just as long as you're aware of the delays. Like the Information and Privacy Commissioner in Alberta has been quite brave and principled recently about access to information as an important pillar of democracy. So um, it's yeah, it's an important tool to use when appropriate. And last note on this: if you get a bad decision from the commissioner, then the only next step is to consult a lawyer about applying to court for judicial review, which you have to do within 6 months of getting the decision, generally. Okay, so there's lots more resources that you could read about. You could read the legislation yourself at cadley.org. Um, the commissioner's offices uh, have very helpful resources about the legislation and the process. So, like both the Information and Privacy Commissioner of Alberta and the Information Commissioner of Canada have a lot of helpful resources on their websites. Um, I'd also recommend reading Charles Rusnell's piece in JSource from 2012 about his experiences with freedom of information requests and what he's learned. It's kind of interesting. It's a short read. And then Drew Uchuk, who is a master's student at the U of C. Now he's at the UBC, I think, but he's done some pretty in-depth academic writings about access to information, especially in Alberta. So if you're really wanting to do a deep dive, I'd recommend checking out his writings. Um, I'll turn it over to questions. Thanks for listening.